Anderson zoning meeting. This is a reconsideration of case 7-2008. First of all, can we get approval of agenda?
I'll make a motion we approve the agenda.
I second.
All in favor?
Aye.
Aye.
And now next, we have election of officers for this year.
I would like to make a motion that we nominate in his absence, Matt Van Sant.
Second.
As chair.
Is there any other nominations?
No other.
Call the roll.
Ms. Cook?
Present.
Mr. Kennard?
Yes.
Mr. Goffard?
Yes.
Ms. McBride?
Yes.
Mr. Heskett?
Yes.
And then I would like to nominate Rob Kennard as vice chair.
I second.
Ms. Cook?
Yes.
Mr. Kennard?
Yes.
Mr. Goffard?
Yes.
Mrs. McBride?
Yes.
Mr. Heskett?
Yes. That means Mr. Kennard can continue this evening.
That's correct. Mr. Chair, whichever way I look, I'd like to make a motion that the commission go into executive session for discussions with our legal counsel.
I second.
Ms. Cook?
Yes.
Mr. Kennard?
Yes.
Mr. Goffard?
Yes.
Ms. McBride?
Yes.
Mr. Heskett?
Yes. Stay seated.
Okay, thank you for your patience. We're returning from executive session and we're ready to proceed with the meeting. The next item on the agenda is the approval of minutes from January 28th, 2012. Do I have a motion?
I motion to approve.
I'll second.
All in favor, say aye.
Aye.
All opposed? Okay. Next item on the agenda is reconsideration of case 7-2008, a major adjustment to the PUD plan for EME Fence Company, filed by Matthew Fellerhoff, Strauss Troy, on behalf of Eman Real Estate Limited, property owner. The property is located at 5060 Batavia Pike, Zoned E in H PUD, Retail and Riverfront Plan Unit Development, Anderson Township. First, I want to outline the procedures the Commission will follow in hearing and deciding this matter tonight. Under the zoning resolution, our decision is subject to appeal to the Board of Township Trustees and then to the Court of Common Pleas. As a result, we must employ different procedures from other cases that are typically presented to the Zoning Commission. Because this is a quasi-judicial proceeding, the Commission will only receive evidence as to whether the application meets or does not meet the standards and criteria in the zoning resolution. We do not want to hear opinions, just facts. As a result, all persons presenting testimony before the Commission, whether for or against the applicant's position, may only do so after being sworn in and being subject to cross-examination. The staff will present a summary of the application. The applicant will then present its case. The Commission members may ask questions of the staff and anyone who speaks on behalf of the applicant. If an attorney presents the case for the applicant, the attorney is not sworn in and is not considered to be a witness. As a result, the attorney's statements are not considered as evidence. Evidence only comes in through the witnesses who testify before the Commission after being sworn in. The burden is on the applicant to present evidence that the application satisfies the standards and criteria for approval. After the applicant presents its case to its witnesses, all persons in the audience supporting the application will be permitted to testify one at a time after being recognized by the chair. When all persons supporting the application are finished, those opposed to the application will then be permitted to testify after being recognized by the chair. If anyone in opposition is represented by an attorney, that party will go first, followed by any members of the audience. As stated previously, all persons wishing to testify, whether for or against the application, may only do so after being sworn in. When testifying, each person from the audience must come forward to the podium after being recognized. speak into the microphone and state their name, address, and any affiliation to the case. All persons testifying will be limited to 4 minutes unless a commission member requests that they will be given additional time. All testimony is directed to the commission only. No comments or questions are to be directed to the applicant or anyone else in the audience. The commission will only hear new, non-repetitive evidence or questions. Should someone wish to show support of all previous testimony, they may do so by following the testimony procedures and stating their support of previous testimony. Now, will all persons who may give testimony this evening please stand, raise your right hand, and swear or affirm? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. Okay, Paul, could you go ahead and read the staff summary for case number 7-2008?
Yes, as Mr. Chair has stated, the applicant tonight is Matthew Fellerhoff from Strauss-Troy on behalf of Eman Real Estate Limited, who is the property owner. The slide reflects the case from October, which was Scott Rogers. The property is located at 5060 Batavia Pike, and the zoning is E-Retail and H Riverfront PUD. And again, the request tonight is a major adjustment to the PUD plan that was approved in 2008. Just a little bit of a background and a little site history. This is Batavia Pike, also known as State Route 32, Signal Hill Lane, and the property in question is there with the star, and this is the Little Miami River to the west, northwest of the site in question. The zoning map, the green identifies the area zoned as H. The red identifies areas E-Retail, and again, this property is also a PUD that was approved in 2008. The yellow represents single-family zoning. There are adjacent properties that are zoned for single-family, and then this is a Speedway gas station generally to the south, to the west of the site in question. Signal Hill Estates is all zoned for single-family. So this is the proposal. And we'll go through a little bit of the site description. The size of the parcel is 0.6 acres, approximately 150 feet on Batavia Pike. It is generally flat with a steep decrease in grade at the rear property that goes into the floodplain. The existing use was EME fence, which is office, storage buildings, and outdoor storage. We talked about the surrounding zoning. The proposed development, this again was approved in 2008 for phased development. And at the time in 2008, the PUD was approved, again, for phased development, and it was approved for an 11,655 square foot storage building. With the second, that was to be the first phase, and the second phase to include a new approximately 1,500 square foot office building with related parking, landscaping, lighting, etc., in the E-Retail portion of the property. There were conditions that were placed on the approval in 2008, which are identified in the staff report. There were 8 conditions. In addition to that approval, there were also variances that were approved as well. Again, from phase 1 and the final development proposal. One of the conditions in 2008 was that construction of the final development proposal shall begin within 3 years of the issuance of a zoning certificate for the rear storage building and be completed within 4 years of the date of this issuance. Primarily because of that condition and because of a multitude of reasons, the applicant came back to the Zoning Commission in October for revised or an adjustment to their PUD plan because they could not fulfill the entire redevelopment of the property at the time. So the request was to modify the PUD plan for a completion of just phase 1. And that is the site plan before you. The existing storage building, which has been constructed, which you could see in the aerial photo, and then a revised parking plan, and that is what was shown in the site plan up on the screen. And again, this was to be completed with phase 1, and the request was also to remove the condition that required the timing of this to be completed. These are some of the site photos looking directly at the existing business. This is the office building in the front, the storage building, the new storage building, which is in the back. This was also another structure that was proposed to be demolished, and I think has been demolished since these pictures were taken in October. This is looking west along Batavia Pike toward Beachmont Levee and the Signal Hill Lane going up to the Estates of Signal Hill. Again, this is looking directly at the site in question. The building that has since been removed for the construction of the parking lot, as you saw on the site plan. And these are just some of the pictures taken from within the site looking back out toward Batavia Pike. This structure has since been removed. And so these were the conditions from the first. So as far as zoning compliance, well, and I can give you the, we'll give you the abbreviated site plan, or the abbreviated presentation for tonight. The applicable plans are identified in the staff summary. These are the areas that are not compliant with the zoning resolution and through which variances would be required for this submittal. Most of them require the parking. So the recommendation has remained unchanged since October and was approval with the modified, or with the adjustment of the PUD plan as contained in the staff summary, consistent with evaluation criteria that was consistent with the Anderson Comprehensive Plan, the Anderson Trails Plan. The use of the property is consistent with the retail portion and riverfront zoning, compatible with surrounding property, size and physical features. Variance requested are necessitated by current configuration and storage area, etc. These are some recommended conditions back in October. And the reasons for granting the variances required. So I'll be happy to answer any questions.
Does anyone from the commission have any questions for staff? Dan? No? Okay. Okay, at this time, would the applicant or the applicant's representative please come to the podium and speak into the microphone, state your name, address, and any affiliation to present your case? Yeah, that's fine.
Good morning. I'm Matthew Fellerhoff, an attorney at Strauss Troy. I'm here on behalf of the applicant. I also have representatives of Lamar Sign Company here also, because frankly that's why we're here. The issue of the billboard that came up in the last hearing on this, and that's why we appealed this, and I presume that's why this has been remanded back to this. Before I proceed, and I'm just going to ask about procedure and how you'd like me to proceed, I will have some questions for Mr. Drury. I can do that right now. I can give an opening statement at this point. I don't know what procedure you would make sense, and then I have a couple of witnesses that I'd like to present.
Mr. Chairman, I would suggest Mr. Fellerhoff do his opening statement, and then if he wants to ask questions of the staff, he can do that, or present his testimony and come back to ask, whichever way. But I think the opening statement probably, Matt, would be the best way to kind of introduce the...
Frankly, I had the understanding, and my client had the understanding, that this was something that was non-controversial. I think it's unrefuted that my client had an original plan in 2008. They had a plan to improve their property. As part of that, they were going to improve the back of the property to accommodate the trail that is supposed to come in the back. For a variety of reasons, my client was unable to do that. One was the economy. I don't think I need to explain the current economic situation to the board. Additionally, Mr. Eamon's father, who was involved in the project, passed away. That created complications for their business, and because of that, it became difficult for them to complete the project. For that reason, they came back and sought to amend the PUD in order to accommodate that reality. Throughout this process, the understanding was, at least from conversations with the staff, that this made sense. It was reflected the reality of the situation, and that really what was going to happen was not a change in the proposal, because it is essentially the same. It was just a change in the timing. That 3-year provision could not be met. So it was, in order to make things valid with the PUD, to allow them to split the project into Phase 1 and Phase 2, and have Phase 2 happen at some later time. The issue that arose here, and I'm going to address that specifically, because if that's all, and if with the staff report as it is right now, I think my client would be happy to submit it with that and ask for your proposal, because I don't think it's controversial. The issue is the condition that was put on this in the last hearing on the sign. And I'm going to be real clear, specific about this. We have our appeal letter, which I believe has become part of the record. I assume it is. That sign was not in any way part of the 2008 PUD. It was nothing that was going to be changed. It was always assumed to continue. It is a legal, non-conforming use. There is a current lease for that sign, and it is a current lease that both parties intend to renew as long as it makes sense to them, and they will testify that for the foreseeable future, they intend to continue to renew that lease. The reason they intend to do that is, one, it is profitable for both of them, and including the fact, you'll hear testimony from Mr. Eman, that the property is titled in the name of an LLC. That LLC, Mr. Eman is a member, but the primary member of that is his mother, who's a widow. Her husband passed away. She receives rent from that LLC, and she receives the rent from the billboard. That is part of the money that she uses to live as an older widow. It is part of her income. It is important for Mr. Eman, and it is important for Lamar Sign to continue to get their income. But it is doubly important for Mrs. Eman, who is the direct beneficiary of these lease payments. I want to go back into the issue of the 2008, and I will ask Mr. Drury some questions about that. I want to clarify the record, because I have some concern that there may be an attempt to rewrite history. The 2008 approval had nothing to do with the billboard. The billboard simply was not addressed because that was not a change to the property, so it wasn't important to mention. It was never identified in the 2008 report as a zoning violation. The 2008 report identified the problems with the property and the zoning violations on the property. It did not identify that as a zoning violation. In 2008, the intent was to continue that sign to be there. Mr. Eman and Mrs. Eman had a current valid lease. If the intent in 2008 with that submission was to take down the sign, they would have been in violation of the lease with the Lamar Company, which doesn't make sense for that to be a conclusion that can be reached. That was not what they applied for, and that was not what they asked for. In 2012, when they submitted this, again, the expectation was that the sign would remain. It is their right. A non-conforming use is the right of a property owner to continue the use. The staff report that was submitted in the fall of 2012 and the staff report that was submitted for the hearing today does not identify the sign as being in any way in violation of the 2008 PUD. does not identify the sign as being illegal in any way, shape, or form. It doesn't discuss the sign because the sign is a legal, non-conforming use, and it's a use that can continue as long as it lasts. I'll address the record in the testimony. We have representatives of the Lamar Sign Company here because they're directly affected by this. Obviously, they have an interest in continuing the billboard. That is their business. From my review of this, and I know you've talked to your counsel about this, my clients have a right to continue this sign. If this board decides, makes a contingency, the removal of the sign, it's in violation of their property rights. Making the approval of a zoning change contingent on removing a legal non-conforming use, which would otherwise be legal, is an unconstitutional exaction. It is something that is not permitted under the law, and members of Mr. Eman and members of the Lamar Sign Company will pursue that and pursue their rights as far as they need to. That is the legal position that we have on that issue. We are entitled to do so. With that, unless there are any questions for me right now, I have a few questions for Mr. Drury.
Okay.
And then I
Okay.
can...
Does anyone on the commission have any direct questions right now for Mr. Fellerhoff? No? Okay.
Okay.
So
Thank
you can address Paul with your questions.
you. Hello, Mr. Drury.
Hello.
I just want to ask a few questions about the record as it is today, and I want to start with the 2008 approval. And I don't know if you need to have anything in front of you, but I just want to clarify a few things. Can you tell me when you're ready? Okay. Well, yeah, I'll let you. We'll get to one point, and then obviously we can winnow it down from there. I want to talk first of all about the conditions that were in the PUD approval at that time. In the PUD approval, in the conditions on that PUD approval, are there any conditions that required the removal of the billboard on the property?
No.
Okay. And I want to direct your attention specifically to condition number 6, just to make sure there's no confusion about that. Condition number 6 says the freestanding signs on the site will be removed with the final development proposal and be replaced by signage that meets the regulations of the Anderson Township zoning resolution. My understanding is that that applies to smaller signs that advertise the business on the property and not the billboard. Is that correct? Is that your understanding?
That condition was unclear, and I was not here in 2008 at the meeting either, and that was brought up for discussion in October, at the October meeting.
Okay.
So I can't answer that yes or no.
Okay. In dealing with zoning issues, do you understand what is meant by freestanding signs?
Yes.
Okay. Does that usually entail a billboard?
A billboard can be a freestanding sign. It is also called an off-premise business sign.
Okay. Now, you earlier testified that there was no specific specific requirement that the billboard come down. Do you agree with that?
Yes, I agree with that.
Okay. Do you see anything in the approval that requires the billboard that required the billboard to come down in 2008?
No.
And in fact, in 2012, did you write the staff report, or were you involved
Yes.
in the writing of the staff
I was.
report? Okay. And did you review the 2008 plans?
Yes.
Okay. And in reviewing those 2008 plans, presumably you needed to take a look at the current condition of the property. Yes?
Yes.
Okay.
Mhm.
And did you identify the existence of the billboard as being in any way in violation of the zoning code at that time?
No.
And in any way in violation of the plan unit development approval at that time?
I did not identify that, no.
Okay. You certainly were aware of the billboard. Is that
Yes.
true?
Mhm.
Okay. Did you go back and listen to the transcript, the testimony in 2008 to get any clarification on the issue of the freestanding signs?
I did not listen to the transcript, I read through the minutes.
You read through the minutes?
Yes.
And did the minutes identify the billboard as having come down, being required to come down?
I could not find clarification.
Okay, did those minutes discuss the freestanding sign, any other signs on the
Yes,
property?
the freestanding signs, yes.
Okay, what were those freestanding signs that were discussed?
There were at least 2 on the property.
Okay, and those were separate, smaller signs?
Yes.
That advertised the business? Yes?
Yes.
Okay, thank you. Do you have in front of you the approval, the plat that shows the approval
From when?
from 2008?
From 2008, yes. I have the zoning certificate.
Okay, and is that what I have here? I mean,
I don't know. What's the date on yours? It should be stamped with a signature by Steve Severs. Dated November 25th, 2008.
yes, that's what I have.
Does the plat match it with the signature down? I can't see. Yes.
Okay, that's the same document. What I wanted to do with this is make this an exhibit. I don't know if we want to take it out of here, or I can submit what I have. Would that be?
It was my understanding that you were going to submit the entire, I think the entire record that was put together in 2008 would be part of the record in this case, so if that's part of
So
the
the
file.
record will be made part of the, so we
Yes.
don't need to? Okay. I just wanted to clarify that. Okay, I'm going to ask you to look generally at the plat. And in there, on the plat, it indicates a Phase 1 section and then a final development section.
Yes.
Do you see what I'm referring to?
Yes.
Okay. And do you understand that maybe you can tell me, what are the 2 separate plats that are contained on this final development plan? What do they depict?
The first was Phase 1, and the second was the remaining phases.
Okay.
The completion of the development.
Okay. Do you see that on the Phase 1 portion of the plat, it indicates, in fact, items on the property that are going to be removed?
Yes.
Okay. And it seems to be a smaller existing building, at least in the Phase 1 section? Do you understand what I'm pointing to?
Yes.
Okay. And then if you go to the final development plan, it shows another existing building to be removed. Do you see that?
Yes.
Okay. All right. So this final development plan shows items that are going to be removed as part of the plans, is that correct?
Yes.
Okay. Does it show the billboard as an item to be removed?
It doesn't show the billboard at all on these plans.
Okay. But it does not show that the billboard is supposed to be removed?
It doesn't show the billboard at all on these plans.
Okay. Right. But you would agree with me that if it doesn't show it at all, it doesn't show it?
Well, it's not on here, right.
All right. Now, explain to me how these final development plans are used. Is this what is seen as being the approval, what the property is supposed to look like in the end?
Yes.
Okay. because I want to be clear. My understanding of the 2008 application was it dealt with the issues of the building and the parking, and the billboard wasn't mentioned at all because the billboard wasn't going to be changed. Can you tell by looking at this approval whether there's an indication of whether the billboard should be removed or the billboard should stay?
No.
Okay. It doesn't address it, does it?
Billboard's not on the plans.
Okay. So it doesn't address it, does it?
No.
Okay, thank you. And in fact, just to be clear, if you look at the final development portion, remember that little building that was shown to be removed on Phase 1?
Yes.
Do you see that it actually is shown as existing on the final development plan?
Yes.
Okay. But likely that building is going to be removed by that same point in time, wouldn't it be?
It was supposed to be removed in Phase 1, yes.
Okay. So what is on that final development plan doesn't necessarily always show what the property is going to look like in the end, will it?
If we issue a zoning certificate, it should, yes.
So are you saying that Mr. Eman could build that small building could remain?
Well, there's another building in its place. It was removed in Phase 1.
Okay. Are you involved in enforcing the zoning code?
Yes.
Okay. Are you the zoning enforcement officer for the township?
I'm the director of the department. We have several.
Okay. At any point in time, did you identify the billboard as it exists on the property as being in violation of the zoning code?
No.
Okay. Do you believe that the billboard is it your opinion that the billboard is in violation of the zoning code currently?
It is a non-conforming billboard.
Okay, but it's legal because it's it's a legal non-conforming.
Legal non-conforming.
Correct. So it is not consistent with the zoning code, but it's permitted to stay. Is that correct?
A non-conforming billboard is permitted to stay.
Okay. Okay.
Are
What
we
I'm trying to
talking
get
about
at-
to 2008 or in 2012?
What I'm trying to get at
Yes.
is, in your opinion, in 2008, your opinion, the billboard does not the existence of the billboard does not violate the 2008 approval. Is that correct?
We never got to the stage of finaling the occupancy for that property, and that was the precursor for them. The property was in violation, and that was why they had to come back in 2012 to address the zoning violation.
Okay. But the
Because they were
billboard-
in violation of the conditions of the approval.
But that had more to do with the timing, not the billboard. Isn't that correct?
Well, I don't know. We didn't get to the final product. We never got there.
Okay.
So I don't think I can answer that question. That was the whole reason why they had to come back to the zoning commission to begin with, because the project wasn't completed.
Well, I'm just talking about the 2008 approval.
Right, and I am too.
And
That's
I'm
why we had to come back to the zoning commission, because we issued a temporary occupancy on the storage building, but the whole plan, the PUD plan, was not completed as was approved in 2008. So yes, I'm talking about the same thing as well.
Okay. If you thought the billboard somehow was inconsistent with the PUD approval in 2008, wouldn't you have included that in your staff report in 2012?
Not necessarily, because the plan coming back in 2012 was not the same one as presented in 2008.
But the only difference between 2012 and 2008, the substantive difference between 2008 and 2012 was really the timing of the phases. Is that correct?
No.
What else?
there were issues with the building department on the base flood elevation of how the building was constructed. And then in 2012, the parking area was identified, well, in 2008, the parking area was identified on the other side of the plan, on the north side. In 2008, it was on the other side. In 2012, it was where the proposed office storage building was. There were multiple differences between 2008 and 2012.
Okay, and this is what I'm getting at. You've identified multiple differences between 2008 and 2012.
Mhm.
You've never identified the billboard as being a difference between 2008 and 2012. Is that correct?
We never got to that point with the 2008 zoning certificate, and then it was discussed.
Okay, but you got to the point with everything else, you just didn't get to it with the billboard, is that right?
No. We were in limbo of trying to final out the building in the back. That was the only portion of the 2008 that had started construction. Nothing else had been finalized. Therefore, we asked them to bring back their plans to the zoning commission for rehearing, basically, to adjust the plan.
Okay. I'm just going to go back to your findings in 2012.
Okay?
You identified a number of issues with the property. You identified, you discussed the 2008 plan. And I'm trying to shortcut having to go through the entire report.
It's fine.
Is it clear, is it fair to say that you identified the current zoning issues with the property in your report, and you did not identify any zoning issue with the existence of the billboard
Yes,
in
it
that
was,
report?
Yes.
And your report presumably covered all the bases with regard to that property. Is that fair to say?
The report was an evaluation of the differences between 2008 and 2012, yes.
Yeah. And you
where
didn't identify
they-
the
Where
billboard?
the applicant wanted the property, where they were at this stage of their development, and how they wanted the zoning commission to review this PUD change.
I don't really want to go much longer on this.
I don't either.
But I'm just trying to get to the question as you
It was
keep
not
going
mentioned in the
general when I
staff
ask you
summary.
specific.
Yes, to answer your question, no, the billboard was not mentioned in the staff summary.
Okay, so is it your testimony you haven't made a determination whether the billboard is currently in violation with the existence of the billboard is currently in violation of the 2008 PUD? Is that what you're saying?
Yes,
You haven't decided that?
because the whole plan, the whole development was not finalized. That was the whole purpose of bringing it back to the zoning commission.
Okay, but with regard to Phase 1, did you look at that? Was there a requirement in the 2008 PUD that the billboard be removed?
Was it a requirement?
In
Was
the
it a-
2008 PUD, that the billboard be removed?
Well, we already talked about the conditions, and we decided no, there was not a specific condition that the billboard be removed.
Okay, so that means that there was no condition in the 2008 PUD
Yes.
that the billboard be removed?
Yes.
Okay, that's really what I'm trying to get at,
Okay.
and I'm sorry if it took me a long time to get to it. One moment, and I'll try to see if I can wrap this up. And I apologize, I didn't see the document. It's a different document that was up there. You had emailed Right, to my office and Mr. Powell last week. It was about a page and a half summary of the matter. Do you know what I'm referring to? What was that document?
That document was a memo. Sorry, it turned off. That document was a memo that I had presented to the trustees when the case was appealed and brought before the trustees in January.
Okay, do you have a
I'm sorry,
copy-
in,
Do you have a copy of that I could look at real quick?
well, there were two memos.
Okay.
The memo that I emailed you was the memo for tonight.
Okay.
But it was basically the same memo that was presented to the trustees for the appeal. Is that the memo you're referring to?
Yes, and
This one was in January.
the February 19, 2013 memo.
Yes. Yes.
Okay, in the second paragraph on the history there, and we addressed this already, but I want to make sure we're clear on that. You discussed the billboard and you call it non-conforming. You see that?
Mhm.
You agree that the billboard currently, as you describe it here, is a current non-conforming use?
Yes.
Thank you. One more second, and I think we'll be finished. The site plan that was submitted with the application in 2012? I can show it. Well, maybe you need to look at it, make sure you get the right ones.
Okay.
Okay. Is this the site plan that was submitted? It has 8/25/08 on the side of it. Did you see that? Do you know why that date's on there, when it was submitted in 2012? Was this,
I do not. His signature is September 20, 2012.
okay, okay. And frankly, there's been a lot of confusion about the site plan, but this is really what I want to get at. Do you see that on this site plan for Phase 1 existing and then the Phase 1 completed, there is demarcated on the site plan the billboard?
Yes.
Okay. And that's a site plan you reviewed, from which in part you produced your staff report?
Yes.
Is that, okay. All right. I don't have any further questions of Mr. Drury. Thank you, Mr. Drury.
Thank you.
Okay. All right, unless there are further questions, I'd like to present some of my witnesses. Would it make sense for me to, I hate to
Do you have
talk to
any,
a witness?
does anyone on the
over-
commission have any questions? No? Okay.
How about if I have the witness stand, I'm going to ask them a few questions, and they'll be general and let them talk.
Whichever
Have them
way
stand
works.
here, and I'll stand to the side. if
Whichever
that's
way
fine.
works, as long as
Okay.
your voice is heard in the recording.
If you don't hear anything, please let me know, but I'll keep talking.
I'm not as, I'm sure they'll let you know, but the recording won't be able to say
Okay,
anything.
well,
so-
we'll try to talk into this, We'll share a microphone. Mr. Eman, will you come up here? Mr. Eman, I'm going to ask you to state your name for the record and explain who you are and what your connection is to the property.
Ron Eman, president of EME Fence.
What's your address, Mr. Eman?
Please,
What's your address?
business address,
Sure.
5060 Batavia Pike.
Mr. Eman, you've heard some testimony about this, and I'm not going to ask you too much about the plan as it's submitted, but perhaps you could address quickly for the commission why we needed to change the plan and why you're asking for this PUD. What's changed between now and then?
Basically, the reason for the change in the plan was due to basically the economy that happened in 2008. We were able to complete or build the building of Phase 1, our storage building, and as to the economy, my father passed away about 6 months after we had started the process of the building. At that point, just because of the economy, the funding for the process, we just had to back off, and we stopped everything at that point from moving forward.
Could you briefly explain you don't have to get too much detail, your involvement with the business and your involvement with the LLC that owns the property?
Basically, as of now, I am basically the president of the company. Daily, day-to-day business items that I take care of. As to the LLC, the real estate portion of it, basically, it is in my mother's name and my name.
Does your business pay rent to the LLC?
Yes, it does.
And does the LLC receive the rent from the billboard?
Yes, it does.
I know you're a member of the LLC. Who receives the profit from those two items of rent?
Basically, those, my mother, which her name is Jean Eman.
And how old is your mother?
She is 74.
And is this a source of her income as a widow?
Yes, it is.
And in 2008, were you involved in the submission of the first PUD proposal?
At that point, my father was in charge of that.
Okay. But you were knowledgeable of it?
Yes.
Okay. Based on your understanding of the submission, did you know, did you have any understanding of whether that submission included removal, a plan to remove the billboard that's on the property?
The billboard was never in question. There were just two adjacent signs that were to come down.
And do you understand those two adjacent signs to be that condition that was discussed earlier with Mr. Drury?
Yes.
In fact, at that time, was the property subject to a lease for the billboard?
Yes, it was still under lease.
And do you know when that lease was signed?
The lease was signed, I believe, in September of '87.
And that lease, how long was the term from September of '87?
Basically, if I remember correctly, it goes 15 years. Every 15 years, it's basically renewed.
So in 2008, were you in the middle of that lease?
Yes,
And if a proposal was made to alter your property and tear down the billboard in 2008, would that have been a violation of that lease?
yes, it would have been.
Is that lease up for renewal anytime soon?
I believe the lease goes until 2017, when we would hopefully renew it again,
Okay. And why would you renew that?
just for the income.
And have you discussed this with your mother?
Yes,
And
yes.
Would she want it?
Yes, she's the one that wants the income.
All during the time period that you've been involved in the property, have you ever been told or requested by any Anderson Township, let me split that up, that's a compound question. Have you ever been told by any Anderson Township representative that that billboard as it stood on that property was in any way in violation of the zoning code, meaning it was illegal and needed to be removed?
No,
In 2008, was there any discussion of bringing down, of removing the billboard?
no,
In 2012, prior to the hearing in front of the zoning commission, was there any discussion, suggestion, or requirement that the billboard be removed?
no,
And you didn't get that from anyone from Anderson Township?
no.
I'm going to ask you to identify this document that I'm going to show you.
This was the original lease that we signed September 29th, 1987.
And is this the lease that was in effect in 2008 when the first PUD was approved?
Yes,
Okay. And is this lease currently in effect today?
yes,
Okay. And when this lease is not, is the term ends, is this the lease that you intend to renew?
yes,
Okay. And do you understand that under Ohio law, because this is a legal non-conforming use, you have a right to renew that lease and continue the billboard use?
yes.
Matt, are you going to submit that as an exhibit? Okay.
I'm going to use it again, so
Okay.
put it right here. Do you want me to give it an exhibit number?
That might be helpful.
Okay. Mr. Eaman, I've identified Exhibit 1. Could you just say what that is for the record, so it's in the record?
EX1,
Yes, I've identified it at EX1, but that is the lease that we've just been referring to?
Yes.
Okay, thank you. If there are any questions for Mr. Eaman, we're happy to talk about it. He's happy to address any issues with the project. I think the board has a good understanding of that, but he's happy to answer any questions.
Does anyone on the commission have any questions for Mr. Eaman?
I've got a question. The deviations between the approved 2008 PUD plan and the current plan that's in front of the zoning commission, can you briefly explain? It's like location of parking, location of future buildings, existing buildings, et cetera?
there was a small storage building on our property. That building has been removed. As of, we've been kind of in limbo, not knowing which way this is going to go as to putting in the new parking area, which goes where that building is removed. The building's been removed. We're kind of ready to move forward, but the process of the sign came up, not knowing what's going to happen. We've kind of stopped at that point. So it's ready, we have not been able to do anything.
I guess my question's really, in the 2008 approved plan, was the parking shown in the exact same spot that it is now with the same number of spaces?
No, no. Basically, in phase one, Our office building that we're currently in now, which is the larger building, that's where the parking lot was going to go.
Okay.
And where the smaller building was, that's where our new office building was going to go. So we've kind of flip-flopped where the parking was going to go until we can move forward with the rest of the plan.
Mr. Chairman, I had a couple of questions for you. Can you tell me what else was not shown on that 2008 plan that was to remain?
That was to remain?
Mhm. There are some buildings that are indicated to remain, and it's been stated here tonight that the billboard was not shown on the plan, but it was to remain. And my question to you is, what else was not shown on that 2008 plan that's to remain?
That's to remain?
Could he look at the plan? I don't think he's had a chance to
Sure.
even look at it, so this would be all new to him, or at least.
Not for a while.
Mr. Chairman, while Mr. Eamon's looking at that plan, I was going to suggest if anybody on the board wanted to take a look at the lease, you could probably do that now in case you have any questions about the lease.
Okay, please ask your question again.
Okay, the question was, what else is not shown on that 2008 site plan that was to remain? The billboard is not shown, and it's your indication that it was to remain. What else besides the billboard is not shown that was to stay on the property?
Okay, so what you're asking is what else was not going to be there?
No,
what you're asking?
what else is not shown on that site plan? The billboard is not shown on that 2008 site plan, but yet it's everyone's testimony that it was to remain. What else was not shown on that site plan that was to remain? Is the billboard the only thing that's missing?
It looks like it. Basically, I would assume the only other thing that's not on here that I can see by looking at this drawing are possibly
And that's, if there's nothing else, that's fine. I just,
If there's something.
no, I mean, I don't see anything.
and that's fine. My other question for you was then, why was the billboard shown on the 2012 submittal that this commission acted on in October? Did someone ask Abercrombie Associates to indicate where the existing billboard was?
That I can't answer. I don't know.
Who worked with Abercrombie Associates to develop those final development plans?
That probably would have been Scott Rogers, who's not here tonight.
Right, and he works for Abercrombie. Scott Rogers does not work for Abercrombie?
I don't think he does.
I was under the impression,
I'm not testifying, so.
he is an architect, you're correct. So Mr. Rogers is the one that worked with Abercrombie, and you worked with Mr. Rogers then? Okay. And who was it that asked that the billboard be put on the 2012 version when it obviously was not on the 2008 version?
That I can't answer. I don't know.
Okay. And that's fine.
Yeah, I don't know.
Okay.
I don't know.
Fair enough. You don't know, you don't know. Thank you.
If I could follow up real quick on that. Are you familiar with this the 2008 plan? All of the items that are shown on here are the things that we're going to change on the plan. Is that correct? And in 2008, it's your testimony that the billboard wasn't going to change on the plan.
Correct.
Correct? Okay. And I know you're not an expert, but the only detail that's shown on here is just the broad outline of the things that are going to change. Is that fair to say?
Yes.
Okay. Now, there was some discussion, and this is a little bit far-fetched, but I just want to make sure it was clear because it was in the report. There was some discussion at the last hearing about the possibility that in the final phase, that the billboard might be impacted by the construction. Do you remember that?
Yes.
Okay. Should we take a break, or?
I think he needs to excuse himself for the evening.
Would it be for the evening?
That's why I think so.
Okay. Should we continue?
Can we proceed with our quorum,
Quorum, yeah.
with a quorum here? Okay, we'll proceed. We'll proceed.
Okay.
He's got some obviously.
Oh, I know, and I don't want to,
I mean, does everybody on the commission agree that we can continue as a quorum with our group? Yeah.
Mr.
Okay.
Huskamp's left, okay.
Matthew?
Yeah.
And I'll ask the commission, we've exceeded our 4-minute limit per testimony. Does everyone want to?
It's fine with, the 4 minute is really for people in the audience, not the applicant.
Okay,
That would be testifying.
okay, okay.
Just, I'm going to be real quick. There was some discussion of a concept that in the final phase, the building that would be constructed might perhaps interfere with the structure of the billboard. Are you familiar with that?
Yes.
Could you comment on that briefly?
Basically, if the building were to be the footings or the foundation, the building itself would be adjusted to accommodate that sign. So the sign would remain and the building would get adjusted as to the size of the building or the square footage of the building.
Okay. I don't have any further questions.
Does anyone on the commission have any further questions? Ann? No? Okay.
I guess a question for the 2008, if the sign wasn't shown on the submitted documents, could have somebody possibly thought it was on the adjacent property for that approval?
I didn't hear what you said. Say it again, please.
You know, if the billboard was not shown on your plat for the PUD, and it's so close to the property line, do you think someone could have potentially thought it was on the Speedway property and
No,
not on your
no,
property? No?
no.
Not at all?
No.
Okay.
The sign is 8 feet within our property, our boundary line, I believe. There's a certain amount of footage that it had to have been installed inside I assume, the property when, I assume, the original permit was issued for it.
Just to be clear, you're not sure of that, though, right? You're saying you assume
I'm assuming what?
that it had to be a certain distance from the property line?
No, I'm not saying that. I'm just saying it's well within inside of our property line.
Okay.
Could I ask one more question?
Yes, go ahead.
And is your property line located out there? Is there a fence
Mm-hmm.
on your property line?
Mhm.
And the billboard is clearly, it was in 2008?
Mm-hmm. Yes. They're both inside of our property line.
And earlier it was stated that the billboard wasn't on the 2008 plans. Is that correct? Were there any signs on the 2008 plans?
I don't think there was any issue with the sign on the 2008 plan.
Were
It was
any of
never, brought up.
the other two signs that were mentioned?
The
were
other
they-
two signs that were talked about have been removed.
Were they listed on the prior plans?
I don't know if they're listed on here. There are marks where they are, but I don't know if they're listed on here as signs.
Okay.
And is there a mark then on the 2008 plan where the billboard is?
I don't see one on here.
Any further questions from the commission?
I just have a point of clarification. Matt, you might be able to answer this. Sure. Under the lease, it talks about, I guess, Mrs. Amon being the owner of the property. Do you know when the property was put into the Amon Real Estate Limited?
To be honest with you, no, I do not know.
Okay.
Was it sometime after the lease was signed?
Oh, yes.
Okay, and it's your understanding that the lease continued under the new ownership, is that correct?
Yes.
Okay.
Was there anything that was filed? I mean, obviously, this lease is on record with the Hamilton County Recorder. Do you know if anything was filed to show that the change in ownership as far as this lease is concerned? Because obviously, from my understanding from your testimony earlier, Mrs. Amon is not the owner of the property at this point, although she's still...
No, she is the owner of the property.
It says on
Well,
here that it's Amon Real Estate Limited.
it's an LLC, yes.
I think he testified that she was a member of the LLC. It's the legal...
Oh, I understand. I'm just trying to clarify for the record, because I'm confused because, the lease says one thing.
Her and I are both part of the LLC.
Okay, so you're both owners of the property.
Correct.
Okay. Was there anything that had to be done in 2002 when this lease renewed, or did it just automatically renew?
It just automatically, if I remember correctly, it just automatically renews itself.
Okay.
Unless we object.
And then the rental price is $1,230 per year, correct?
Correct.
And
But what is probably listed on there should be what it is.
Okay, so it doesn't increase per year or even upon renewal?
No, that's, if you look at that paper, that's the 1987 portion of it.
Is there another portion that,
That's what it was in 1987.
okay, and what is it today?
To be honest with you, I don't know, because I do not receive that payment.
Is there a lease currently in effect?
Yes.
And we don't have a copy of the current effect, or the current lease?
That is, I believe, that is the lease.
Okay.
But again, that was written in 1987. I'm sure it's been adjusted over the last, 20-some-odd years as to what the payment is.
But you don't have that most current document?
No, I do not.
Mr. Eman, do you know whether, in fact, there is another document?
I do not believe there is.
Okay. And so your belief is that that is the lease that applies to this property?
Correct.
Okay.
Including the payment of $1,230 a year?
Again, I don't know that for sure. I'm sure it's gone up, but I don't know what it is.
And I've just looked at this briefly, so I haven't read it in the entirety, but I've glanced through it all, but I don't see anything that talks about a yearly or some, any increase. I see the right of the sign company to decrease the rental rates for certain reasons, but I don't see anything, and I can be corrected because, like I said, I haven't read through this entirely, and I understand somebody from the lease company, or the sign company is here, so we might be able to have that question answered. But I assume that regardless, you indicated earlier that your mother's, this is part of her income, not her sole source of income, is that correct?
It is a part of hers.
Okay, a small part, I assume?
A small part, yes. But she's on a fixed income and she uses it.
Oh, understand.
And just since we ended up on that subject, is that income important to your mother?
Yes, it is.
In fact, when she heard about the board's decision on this, what was her reaction?
Matt, I think that's probably improper. She's not here to I mean, nobody can cross-examine on that. I mean, they can, I guess, cross-examine him, but I mean, if he's going to make a statement for somebody who's not here, I don't think that's fair to put into evidence because the board can't cross-examine her on that.
Yeah, it doesn't have any relevance to the zoning resolution, so.
Was following up on questions about what her income was.
And that was a straight factual question about whether or not this lease, the payments had been adjusted, and I agree, Matt.
But it's in the same area. Anything else?
Does anybody have any other questions? No? Okay. Thank you, Mr. Eman. At this time, we'll take testimony from persons in the audience who support the application. Oh,
We have one more.
oh, I'm sorry.
Mr. Fahey. And we'll be quick, I promise.
Can we pause and
Sure.
then change it?
Sure.
Please just make sure you're speaking into the microphone.
Okay, thank you. Mr. Fahey, could you introduce yourself to?
Yes, I'm Tom Fahey from Lamar Advertising,
Can you state your address, please?
1260 Edison Drive, Cincinnati.
Mr. Fahey, I only have a few questions. Exhibit 1, I don't know where it ended up.
Hey, Beth, can you make sure you're speaking to the microphone, please?
I'm handing you what's been labeled as Exhibit 1. Could you identify that for the board?
This is a billboard lease between Lamar Advertising and Jeannie Ehrman.
And I'm going to ask you two questions about that. One, you've kind of heard some questions about, and the other one, at the top of that, it says Patrick Real Estate Lease, and it talks about Patrick Media Group, Inc. And I'm just going to state, that doesn't say Lamar, and this says Jeannie Eman, and that doesn't say the Eman LLC, which has been discussed. Do you understand that this lease, which is Exhibit 1, is the current lease between Lamar Advertising and the Eman LLC, who is the applicant here?
Yes.
Perhaps, we already heard the discussion of the LLC. Could you explain what Patrick is vis-a-vis Lamar?
Lamar is a successor in this lease to Patrick Media through acquisition.
This lease is renewed once automatically, is that correct?
Yes.
Okay. And just so everybody's clear, what business is Lamar in?
Lamar is a billboard company which is in the business of renting land for advertising use.
With regard to this billboard, does Lamar want to lose the use of this billboard?
No, this is a very valuable position for Lamar, and we'd like to continue to operate it.
With regard to this billboard, when the lease is set to renew again, what would be the intent of Lamar? What's the intent of Lamar with regard to the renewal?
Lamar would be very interested in continuing the lease at this location.
So it's your testimony that Lamar, in the ordinary course of business, would renew the lease?
Yes, we generally renew about 98% of all the leases that we have in this area.
There's been some discussion of the amount of the lease and the value of that lease, and I'm going to just ask you this question. and I don't know how detailed you need to get into this, but are you able, looking at this, have you looked at the income from this billboard?
Yes, I have.
Okay. And from the income from this billboard, are you able, as you do, to identify what you think, and I know this is rough, but the value of the billboard to the Lamar Company?
Yes, we value the billboards based on previous 12 months billing, and based on the previous billing from this billboard, the value that this location would have for sale by, or to be purchased would be roughly $90,000.
I'm sorry, did he say 9 or 90?
90,000.
90,000, I'm sorry.
90.
And if, let me restate that. Do you understand this lease to be a property right of Lamar's?
I'm not sure I understand your question.
Matt, is he an attorney? What, I mean, you're asking a legal question, a legal opinion, I think.
Okay.
I mean, you can make argument as far as that later, but I mean, I think you're asking a non-attorney witness.
Okay. He's already indicated what the value of it is. Is there anything else that you think is important to say?
It just is a very valuable asset to our company. We don't have much exposure in eastern Hamilton County, and this site brings us a lot of opportunity for advertisers to target this portion of the county. When I drove by it today, I noticed that the Cincinnati Zoo was on one side of it, and, you know, we like the opportunity to communicate to people in Anderson Township, and that's what this location provides for us and advertisers in greater Cincinnati.
Thank you. If you have any questions for the witness.
Does anyone have any
Happy to
questions?
answer any.
One question, were you an active party for the 2008 PUD approval?
I was not.
Okay. No one with the Lamar was either? That you know of?
Not that I know of.
And you note that that the lease from 1987 is the current lease still. How does Lamar handle any changes to the lease terms?
We abide by the lease as it's written and signed. If there are any lease terms, we would document those and abide by whatever lease changes there would be to them.
So the current dollar figure on the lease from 1987 still remains?
Yes.
Okay.
With your work with Lamar, do you represent Lamar in different zoning issues or land use issues?
Yes.
Paul, could you give the witness the 2008 plan? Give you mine, but you need a microscope. If you were looking at that site plan, would you know that there was a billboard on that property, or that there was a billboard that was to remain on that property?
Bear with me, I'm not familiar with this site plan at all, so I'm just sort of looking at it from scratch. I'm sorry, what was your question again?
The question was, could you tell from looking at that site plan that, one, there is an existing billboard on that property, and two, that existing billboard was to remain on that property?
From what I see, I can't tell that, no.
And it's your billboard?
Yes, it's on my billboard, yes.
Thank you, that's the only other question I have.
Mr. Fay, we talked about what you consider to be the value of the billboard per, for Lamar, which is, I think you said $90,000 if you were going to sell it or purchase a similar location. Is that correct?
Yes.
What is the typical rent that you would be paying to a lessor in 2012 versus what you're paying to the Emans from the 1987 lease?
Each individual lease is different, and there's a wide range.
What would the range be? I mean, for a similar billboard in the similar type of location as far as number of views, things like that? Because I assume that you calculate the different rent that you charge to a company that's going to be placed on the billboard based on location, number of views, things like that. So for a similar billboard with similar number of views, what would you be paying a typical lessor in 2013 for that same kind of space?
Anywhere from $1,200, which it is now, maybe to $2,000. There's a lot of variables that are involved in that, and it's really hard to pin down an exact amount.
So the value of that billboard has not gone up since the lease was entered into in 1987. Is that what you're saying?
Well, I said between $1,200 and $2,000, so with the value of what we pay the landowner might not be the same value which we value the sign.
Okay, so I'm just trying to be clear because it seems to me this is an important point. Obviously, you've testified the value to Lamar, but so you're saying that if you were buying or if you were leasing this same billboard in 2013, you'd be paying anywhere between $1,200 to $2,000 per year. Is that correct?
Well, you pay whatever you can negotiate with the landowner.
Okay. To be real straight with each other, I understand that it's all about negotiation. So are you saying that the range that you would expect to be paying would be between $1,200 and $2,000 for the billboard in this particular location?
Again, there's a wide variety. There's no two billboard negotiations that are exactly the same. I have several hundred billboards in the area, and none of them are exactly the same. So the relationship with the landowner, other term, there's all kinds of things that go into negotiating the value that we are able to pay to a landowner. So it could be double that. It could be. It's really hard to sit here and tell you what we would pay until we go down that road with the landowner.
So what is the range that you typically pay then? Let's say in the last 5 years for a billboard of that same size in a comparable location. So give me the low range that you would expect to try to negotiate to, and the high range that the lessors with knowledge would negotiate with you for.
It's really hard to say. I wouldn't want to pigeonhole a position like that.
It makes it tough, frankly, for the board to have an understanding then of this billboard expired, the lease expires in 2017 if it's not renewed, and it seems to me that based on the economics that this billboard lease was entered into in 1987, it's probably beneficial to the landowner, the lessor, not to renew at that same price in 2017. Mm-hmm. Isn't that the way you would see it if you were the landowner? They negotiate a higher price from them?
That would be their right to do.
Right. Okay. Thank you.
And I'm really going to say just an objection because we had the landowner testify, and we didn't ask him the question. He said he would renew, and I just want to be. We're speculating what the landowner would do, and that hasn't. I don't know that this is an appropriate question for this witness.
Well, I don't know that I would have had to get there if I would have gotten an answer to one of my earlier questions, trying to identify what the value of this lease would be to a landowner for a similar lease at the same spot. Obviously, Lamar has to come up with a charge that it charges businesses that advertise on the space. So they can come up with that, and I assume that they know how this spot compares to 5,000 other spots across southwestern Ohio. And so I think it's disingenuous to say, I don't know what a landowner might be able to get for this particular lease. So
I wasn't talking about the generality. The question was specific to this landowner.
I understand.
And what, would this landowner, the question as was proposed, but it was almost a statement, was would this landowner renew the lease? And that's where I asked the question, because this landowner has already testified that he would renew the lease.
okay, I can rephrase the question. Sir, if you were advising somebody in 2013, let's say in 2017 when their lease was coming up for renewal, and a company was paying them the price that was, you know, fair market value, if you will, for the same billboard in 1987, would you recommend that that person try to renegotiate that lease with the lessee, or would you be satisfied with that payment that was negotiated 30 years ago?
No, I would, as a landowner, I'd try and get more money.
Okay.
Yes.
Thank you.
And can I ask one question to follow up to that?
Absolutely.
Matt, can you talk in the microphone?
Oh, I'm sorry. Thank you. Thank you. You're familiar with the billboard business, obviously, and you do renegotiate leases with property owners. Is that correct?
Yes.
But the bottom line is if you have a non-conforming billboard, if the lease is not renewed, what happens to that nonconformity under your leases generally?
It's lost.
Okay. And so if the lease is not renewed, Lamar loses money, is that correct?
Yes.
And the landowner loses money.
Correct.
Okay. I'm not going to ask you to speculate. How often does it happen that a lease that's legal does not renew because of price issues?
Very rarely. We all generally come to terms with, like I said, 98% of our landowners
Because otherwise,
for renewals.
Because otherwise it would be self-defeating to both parties. Is that correct?
Correct.
Okay, thank you.
Does anyone have any more questions for this witness? No? Okay, thank you. Do you have any more witnesses, Matt?
I have no more witnesses.
Okay, thank you. Is there anyone else in the audience who's sworn in that would like to voice their support for the application at this time? Okay, and I'm assuming there's nobody in the audience who opposes the application, is that correct? All right.
Mr. Chairman, I've got a question. Is this sort of a revisit of the entire approval process, or are we looking at the current phase as all new at this hearing? Because I've got some questions generally on the layout of the land.
Okay, yeah, go ahead.
Okay. I guess Mr. Eman.
Mr. Eman, will you come back up here, please?
Probably be addressed to you. The plan shows the gate being relocated closer to Batavia Pike,
Yes.
and without sort of this drawing I have to scale, it looks like it's about 20 feet off of the pavement of Batavia Pike. Is there
I believe that's what it shows on the drawing.
Okay. I'm assuming it's relocated there because it's sliding and you have to bypass the new parking area, correct?
Correct.
Is there sufficient room for your trucks to pull in when the gate is closed and be totally out of the traffic lane?
Yes.
20 feet is sufficient for your trucks? The flatbeds and all that?
The way, I believe the way it's drawn, now again, you have to remember, this is in phases, so some of this has been, I guess, amended as to how we can do this. At a later date, there's going to be another gate that would be added, so we would have more width. But as of the way it's drawn now, the gate is open all day long. Our trucks have no reason to be outside the gate if we're closed. So we would open the gate as we come in with a regular vehicle. The parking area is going to be inside the fenced-in area. At that point, the gate's open, our trucks can come in and out, delivery trucks can come in and out. So it should not be an issue.
So the gate's only closed when the business is closed?
Correct. When the business is closed, that's when the gate is closed.
And you have no sort of typical trucks that are outside the gate when the business is closed?
If they're outside the gate, they're not going to get unloaded. They're going to have to go somewhere else or come back at another time.
Does anyone have any other questions for Mr. Eman? Okay, thank you.
Thank you.
Mr. Chair, I'd like to make a motion that we go into executive session for purpose of deliberations.
Okay.
I'll second.
Second. Allison, will call roll?
Ms. Cook?
Yes.
Mr. Coffin?
Yes.
Ms. McBride?
Yes.
Mr. Smith?
Yes. Thanks for your patience. We're right.
Mr. Chair, I would like to make a motion to close the hearing and to direct our legal counsel and our staff to prepare a resolution to reflect the deliberations of the executive session.
I will second.
Okay, Allison, will you call roll?
Ms. Cook?
Yes.
Mr. Coffin?
Yes.
Ms. McBride?
Yes.
Mr. Smith?
Yes. Okay. Do I have a motion to close the meeting?
A motion to close.
I have a second.
I'll second.
All in favor, say aye.
Aye.
Aye. All opposed? Aye. Thank you.
Yeah.